Hello, and thank you to everyone for joining this ACLU Town Hall. I'm Amber Hikes, Deputy Executive Director for Strategy and Culture at the ACLU. My pronouns are they and she, and I'll be your moderator today. This is my first time hosting one of our town halls, and I am honored to be here with you. As you know, we're here to talk about the Supreme Court term, which ended on Friday. During the term, the court decided cases that will affect a myriad of our rights, including voting rights, free speech, Indigenous justice, racial justice, and the right to be free from discrimination based on who we are, among others. With our most cherished values on the line, we are providing this space to come together as a community to discuss what we're facing. Over the next hour, we'll talk with a panel of ACLU experts about what the court's decisions mean for our fundamental freedoms, what the path forward looks like, and how you, our incredible supporters, can take action and stay involved. For today's discussion, I'm joined by three of my esteemed colleagues, David Cole, Cecillia Wang, and Deirdre Schifeling. They sit in the ACLU's legal and political advocacy departments, which have been working around the clock to protect our civil rights and civil liberties. Thank you all so much for being here. Now, my friends, we have a lot to cover today, so let's dive right in. I first want to bring in David Cole to get his impressions of this Supreme Court term. David is the ACLU's legal director and a constitutional law expert who has argued before the 9 justices, so he is very well acquainted with this court. Welcome, David.
Thanks for having me.
So glad you're here. Now that the term has officially come to a close, can you share some of your overall thoughts about what this latest Supreme Court term was like, and how can we make sense of it?
Yeah, so, there's no question this is a deeply conservative court. I don't think we have any illusions about that. And it was a devastating term, in particular for equality, and in particular on the last 2 days of the term when the court upended 45 years of precedent with respect to affirmative action and held for the first time ever that a business open to the public can turn away gay customers because they are gay if the business owner objects to celebrating their wedding. So it was some very troubling decisions, but it's also important to note that the term included a lot of significant victories for civil rights and civil liberties, ones that I think nobody would have predicted at the outset of the term. And so we won major cases, and when I say we, those who care about civil rights and civil liberties, on voting rights, on Native American rights, criminal defendants' rights, free speech rights, the rights of the indigent. So it's a mixed term. It's a term in which Justices Kagan, Sotomayor, and Jackson were in the majority more often than Justices Alito and Thomas, the court's most conservative justices. And one measure of how different this term was from last term is how we did, the ACLU in the court. We file more briefs in the Supreme Court than any other non-governmental organization historically. In the last 2 terms, we filed 18 briefs in cases, both cases we were litigating directly and cases in which we were friends of the court. Last term, we won 5 of those cases, and they were pretty, obscure cases, and we lost 13, including the Dobbs decision most prominently. This term, we won 11 of the 18 cases we were in, and the victories included some very, very significant ones and ones that I think nobody predicted at the outset. And so, I think the real question is what changed? My view is what changed is people pushed back. The country responded very critically to the court, and rightly so, after last term's debacle. And the court, heard that. Didn't hear it in every case. It picked its battles, but in many more cases than I think anyone thought, we ultimately prevailed.
Absolutely. So, David, as you mentioned a little bit earlier, the victories are significant, but despite the victories in this term, the Supreme Court remains hostile to many civil liberties issues, and that's an important point. That was made clear, of course, by bad decisions on affirmative action and LGBTQ equality last week, and of course, as you mentioned, the Dobbs decision last term overturning Roe v. Wade. So we're going to discuss affirmative action, LGBTQ equality cases in detail a little bit later on. But for right now, I do want to ask you, what do you see as the path forward from here? So many of our supporters are asking, what's next? So
Right.
some insights.
So I think a couple of things. First of all, the fact that we've seen this shift, and I think really in response to protest and in response to criticism, means we have to keep protesting, we have to keep criticizing, but we have to not lose sight of the fact that we can actually push this court to do the right thing in some instances. The other thing I think is important to keep in mind is that the vast majority of cases in the federal court system never get to the Supreme Court. And we still win regularly in the lower federal courts. We have a streak now of striking down 6 state laws banning gender-affirming care in federal courts across this country. We haven't lost one yet. And so, those cases may go up to the Supreme Court, they may not, but we can still win there. And then I think the last point is you have to look for alternative forums. And so we've started something called the State Supreme Court Initiative that I know we'll talk about later, that really tries to look to state Supreme Courts and state constitutions to advance and protect civil rights and civil liberties.
Wonderful. Thank you so much for sharing that analysis, David, and particularly for lifting up those extraordinary victories for gender-affirming care and gender diverse youth. I want you to continue to help us understand this term better, and let's dive into some of the details of some of those key decisions. And let's start with the affirmative action case. I know this is something that's very top of mind for the folks on this call. So last week, as we all know, Supreme Court ruled that Harvard and the University of North Carolina's affirmative action policies violate the Constitution's Equal Protection Clause. In doing so, the court struck down affirmative action programs in college admissions across the country, overturning, as you mentioned before, 45 years of precedent. So David, could you break down the case on affirmative action for us? What does the court's decision mean for the future of educational equity in higher ed? And does this affect other areas too, like our workplaces, for instance?
Yeah, so look, affirmative action has been a central part of the effort to repair some of the damage that has been done by historic discrimination and systemic inequality in this country. And colleges and universities are a particularly good place to have programs like affirmative action, because you can pull from across the country, you can pull together an integrated community with diverse viewpoints and diverse perspectives. You can bring in folks from marginalized communities, provide opportunities not only to them but to everybody to learn from them, and that's why every top university and college in this country engaged in affirmative action and defended affirmative action. That's why the military defended affirmative action. That's why businesses defend affirmative action. It's good for America. But this court, 6 justices on this court don't think so. And they essentially ended it. What they said was diversity, which is the rationale that has heretofore justified the consideration of race as one factor in a holistic assessment of an applicant for a school. Diversity is just too mushy. They said it's too imprecise. We can't tell when a school is sufficiently diverse. We can't tell what the educational benefits of diversity are, and therefore it's not a sufficiently strong interest to justify the consideration of race. That, notwithstanding the fact that the court in many other contexts has upheld as compelling interests that justify these sorts of actions all kinds of interests that are just as mushy or imprecise. National security. How do you measure national security? And yet that has long been recognized as a compelling interest. The integrity of the judiciary. About 10 years ago, the Supreme Court said the integrity of the judiciary is a compelling interest and therefore justifies what would otherwise be struck down under strict scrutiny. That can't be quantified, and yet the court recognized that. So it's a case of Trump appointing 3 justices who turned the existing 3 justices who had been dissenters on affirmative action into the majority. It's as simple as that. Now, I will say there's one silver lining in the decision, and it's an important silver lining, really important silver lining, and that is at the end of the decision, the court says nothing in this opinion should be interpreted to bar universities from considering race in the context of an applicant writing an essay and explaining how his or her race has contributed to some quality or characteristic that is relevant to that school's admissions policies. And so they left the door open for the consideration of race. They also made clear that race-neutral alternatives are permissible to continue to try to maintain diversity. So if schools and universities are committed to doing this work, I think they can still try to create diverse classes. It's going to be much harder. There's going to be a lot of pain and suffering and a lot more inequality as a result of this decision. But those two, caveats, important caveats, I think at least begin to point for a way forward.
Thank you for lifting up that nuance, David. It is indeed a setback to educational equity and opportunity, but that's an important nuance to lift up. And this is certainly not where the fight ends. I'm going to take a minute now to actually shift us and bring in Deirdre Schifeling into the conversation. Deirdre is the ACLU's National Political Director, and I believe this is Deirdre's first town hall as well. So thank you so much for being here today, Deirdre.
Yes, it is. Thank you for having me. I'm excited to be with you.
Good to see you. So let's shift. In the aftermath of these decisions, what comes next? What actions can colleges and universities take, as well as the folks who are watching now?
Yes. Well, thank you so much for that question. And absolutely, the affirmative action decision was a major setback for the multiracial equality and democracy that we all want. And we know that race-conscious admissions policies increased access to higher education for all students, particularly underrepresented racial and ethnic groups who face systemic barriers. And I'll add that this court's decision revoking President Biden's student loan debt program effectively delivered a 1-2 punch to millions of Americans, locking them out of economic opportunity and worsening wealth inequality in this country. However, even with the removal of affirmative action, colleges and universities still have a responsibility, just as David referenced, to do outreach and work hard to recruit students from all backgrounds to create thriving campuses. Colleges and universities have long touted the importance of a diverse student body. This decision does not change the importance of that goal. And there's a number of things that colleges and universities can do right now to ensure that every student gets a fair shot. For instance, as President Biden urged on the day of the decision, colleges and universities should implement holistic application reviews to consider a student's access to opportunity, factors like the percentage of students on free and reduced lunch in their school, experience as a first-generation college student, socioeconomic outcomes, among other data that they should and they can consider that. Schools can also go test-free and eliminate the barrier that standardized testing creates for underrepresented students. They can commit to expanding financial aid programs to increase access and opportunity for students to attend and pay for college. They can do away with legacy as a factor in admissions. And there's some efforts underway to countersue that is a discrimination. And they can expand targeted recruitment to underserved communities and develop robust middle school and high school pipelines. So those are concrete things. In California and other states that banned affirmative action many years ago, we unfortunately saw a significant decrease in Black and Latinx enrollment at flagship institutions as a result. We also saw students of color at less diverse college campuses experience more discrimination. That said, we know that when colleges create opportunities for learning, students across every race, ethnicity, and income step into them. Students become well-rounded adults when they learn from others and interact with different perspectives. And all students deserve a high-quality education and a safe learning environment and a diverse student body that enriches the educational experiences of all students. So our nation's future as a thriving multiracial democracy depends on students having the freedom and opportunity to learn, to work together, and understand what unites us. We must invest in pathways that increase access to opportunities for students across all races and ethnicities and address discrimination and the systemic racial inequalities that persist. We will continue to fight to tear down barriers to opportunity and to ensure that pathways to higher education are open to all. And you can join our grassroots army of volunteers and sign up to join the fight for affirmative action and educational equity at aclu.org/affirmative action. That's aclu.org/affirmative action.
Thank you, Deirdre. Leave it to our political director to give us that call to action. That's the one that we needed. Thank you for those concrete tools, those concrete steps that colleges and universities can take, as well as what we can all take as supporters in this fight. I do want to really encourage all of our supporters to take part in this effort that Deirdre just lifted up. We have got to raise our voices in the wake of this decision and keep fighting together. Let me be very clear. Racial justice is core to the ACLU's work, and we will never stop advocating for equity in school, at work, at the ballot box, and in so many other areas. You can count on the ACLU for that. In fact, in our next segment, we're going to actually talk about a major victory against racial gerrymandering. So let's get into that. In a surprising victory, the Supreme Court ruled in our favor in Allen v. Milligan, our joint challenge to Alabama's racially discriminatory congressional map, which violated the Voting Rights Act of 1965 by unfairly diluting Black political power. The court also ruled in our favor in Moore v. Harper, a North Carolina redistricting case. I'm actually going to ask Cecillia Wang to share more about these wins and what they mean with the 2024 elections looming on the horizon. Cecillia is the Deputy Legal Director at the ACLU and leads the work of the ACLU Center for Democracy. Thank you so much for being here, Cecillia.
Thank you, Amber, and thank you, everyone. So as Amber said, I have a happy job of sharing two surprise victories from the Supreme Court at the end of the term. In both of the redistricting cases that the court took up this term, a majority of the court, a 6-3 majority, rejected extreme far-right arguments that were advanced by the state legislatures, Alabama in the case of Allen versus Milligan, and North Carolina in the case of Moore versus Harper. So let's start with Allen versus Milligan. This was a case brought by the ACLU and LDF on behalf of Black voters in Alabama who were challenging the racially gerrymandered congressional districting map that the state legislature drew. We brought a claim under Section 2 of the Voting Rights Act to challenge that racial gerrymander. Black Alabamians make up 27% of the state population, and yet the legislature for the new 2021 map basically redid the 2011 map, which gave Black voters a fighting chance of electing their preferred candidate in only one of 7 congressional districts. Our position was that with the growth in the Black voting age population in Alabama, there should have been more than one district for Black Alabamians to have a chance of electing their preferred candidate. We won a ruling from the 3-judge federal district court, which, by the way, included 2 Trump appointees, saying this was not a close call, clearly an illegal racial gerrymander. And in the surprise ruling at the end of the term, the U.S. Supreme Court affirmed the lower court ruling in a decision by the Chief Justice. Now, what's important about Allen versus Milligan is not just that the Supreme Court affirmed our lower court victory, but it repudiated the extreme far right classic argument that the Alabama legislature was advancing, that you shouldn't consider race even when you're obligated under law to uproot a history of race discrimination in voting and redistricting. The majority of the court, again 6-3, rejected Alabama's extreme and retrogressive position, advancing this sort of colorblind theory, which unfortunately the court did buy in the affirmative action cases. And that clears the way for us to go back to Alabama and implement the lower court's order requiring a fair map that gives Black Alabamians an equal voice in the governance of their state. The second case I want to cover is Moore versus Milligan, which is a partisan gerrymandering case in which the ACLU filed an amicus brief. The challengers won in the North Carolina State Supreme Court, which held that the North Carolina legislature deliberately drew the congressional redistricting map to favor Republican candidates. Now, what happened next was extremely worrisome, and this is where the happy surprise comes in. The state of North Carolina came into the Supreme Court and argued that under this so-called independent state legislature theory, which first came up in an opinion by Chief Justice William Rehnquist in the Bush v. Gore decision back in 2000, state Supreme Courts should have no role in reviewing what state legislatures do in terms of redistricting. This was an extreme theory that is totally at odds with Supreme Court precedents up until now. And the Supreme Court, when it granted cert in Moore versus Harper, specifically said, we're going to decide on whether this independent state legislature theory is valid or not. Most of the pundits and observers were very worried that the Supreme Court would buy into the independent state legislature theory. Again, an extreme argument that's at odds with all the previous Supreme Court decisions. But in a happy decision, again, a 6-3 majority and a decision by the Chief Justice repudiated that so-called independent state legislature theory and said that the federal elections clause in the US Constitution still leaves a role for state Supreme Courts to do what courts do, and that is to decide whether the other branches of government are acting in compliance with the state constitution. The Supreme Court affirmed the North Carolina Supreme Court's decision that struck down the 2021 congressional map that the legislature had drawn to favor Republican candidates.
Thank you, Cecillia. This was a very challenging term, and so we are desperately appreciative of the good news when we can get it. Tell us a little bit more about what these decisions mean for our work to protect voting rights, particularly as we move into those 2024 elections.
Sure. So Milligan and Moore are really watershed victories, but viewed another way, we really just dodged a bullet that far right state legislatures had been advancing. As I said, observers really expected the Supreme Court to gut Section 2 of the Voting Rights Act and adopt these far right theories of color blindness and the independent state legislature theory. But really what happened in these cases, if you look at the longer arc of justice on voting and redistricting, is that we are successfully fighting our way back from the Supreme Court's watershed decision in Shelby County versus Holder back in 2013. That decision gutted Sections 4 and 5, the pre-clearance provisions of the Voting Rights Act. And I think what this shows is that, like water on stone, as our leader Anthony Romero always says, we and our partner organizations are fighting back to preserve what's left of the Voting Rights Act in the courts. And as Deirdre, I think, will tell us, we're fighting back to win back the robust voting protections of the Voting Rights Act and more and better before Congress. And we have long-range plans to do that. The basic lesson, I think, of these two decisions is that a 6-3 majority of this Roberts Court is not buying what state legislatures are serving up in the way of voter suppression and racial gerrymandering that is really meant to dilute the value of Black Americans' votes.
Thank you so much, Cecillia. These redistricting decisions are really important victories, and it's truly the boost that we need as we work to continue to protect voting rights in the lead up to 2024. I'm going to bring back Deirdre at this moment to talk about the power of the people when it comes to both the Supreme Court and our 2024 elections. I know we have some folks who are ready to get involved, ready to get engaged. And so, Deirdre, what role do you think we, the people, played in influencing the court's decisions, particularly in these redistricting cases?
Yeah, thank you for that question. So I think the Supreme Court is undoubtedly influenced by their historically low level of public confidence since their Dobbs decision a year ago, which stripped away the right to access abortion, a right that people in our country had had for 50 years, and which more than 2/3 of Americans support. So since the Dobbs decision, the public has increasingly viewed the court as partisan, as ideological, and has questioned its legitimacy. And I think this shift in public sentiment, coupled with increased media scrutiny and the court's multiple ethics scandals in recent months, has given the majority, or at least Chief Justice Roberts, some pause. The redistricting case was a very surprising win, and I think was in part an attempt to appear more moderate and supportive of democracy after prior decisions, as Cecillia just referenced, gutting the Voting Rights Act and allowing partisan gerrymandering. And these decisions came right before ruling on the affirmative action and student debt cases, amongst others. There was a lot of public activism that helped generate media coverage and showcase the public support for fair representative districts that I think really set the stage for this decision. Since the Dobbs decision, we have seen a huge and sustained surge of young people, majority young women, but all kinds of people, registering to vote, getting involved with local campaigns, and fighting for their rights, including getting more involved with elections. The right to vote and have your vote be counted, and the right to control your own body are both about fundamental equality. And young people see that, and they want a country and a government that supports equality and democracy. That's the message they've been sending to this Supreme Court for months, and part of what I believe caused the court to moderate a little bit.
I think you're exactly right, Deirdre. And like you said, our voices absolutely do matter. We all have a part to play in pushing for progress here. And of course, that goes for our elections as well. So tell us, how can we all link arms and drive the issues that we really care about as we look ahead to these 2024 elections?
Yes, I thought you'd never ask. So the top issues for voters right now are the economy, which is perennially the top issue, and abortion. After the Dobbs decision, people who support abortion rights are 20 points more motivated to vote than people who don't. And they will only vote for someone who shares their views. It's become a litmus test issue for many voters. This is a major shift from the pre-Dobbs decision world, when abortion was really an issue that was much more motivational to anti-abortion voters. So the world has flipped. We have a job, I think, right now to lean into the rage and grief that voters are feeling around the overturn of Roe, and help galvanize voters to go to the polls and elect people who share their commitment to rights and liberties. This high salience issue can help us elect civil rights and civil liberties majorities in Congress and in the White House, so that we can make progress on protecting abortion and birth control, which they're coming after next, protecting democracy and voting rights, immigrant rights, and so much more. Voters will not accept their rights being taken away, and we have seen that in ballot initiatives on abortion access across the country, in places like Kansas, Kentucky, Michigan, as well as in recent elections, from state Supreme Court judges to Congress. Voters will turn out in droves to vote against politicians who try to strip their rights away, especially reproductive rights. So I think our charge is to harness this energy to elect people who will protect rights and democracy, and at the same time, tee up a federal bill protecting access to abortion to move swiftly through Congress in 2025, and pressure the Senate to remove the filibuster, which is the rule in the Senate that requires 60 votes to pass legislation as opposed to just a simple majority. Remove that filibuster to pass it. Once the filibuster is gone, we can also pass the critically important voting rights and democracy legislation that has been stuck in Congress for years. We need this legislation in order to end the voter suppression tactics that many Republican-controlled states are implementing to prevent people of color, particularly Black Americans, and young people from voting, and to end racial and partisan gerrymandering, which has now created fewer competitive congressional districts than at any point over the last 52 years, as well as more fair state legislative districts. Opponents of rights and liberties are literally rigging the rules. They're changing the rules to erode democracy because they know that the majority of the country doesn't support their agenda. The only durable way for us to protect reproductive rights and all rights moving forward is to protect voting rights in democracy so that we have an accountable representative government. Our ability to protect rights and liberties depends on a functioning democracy, and the ACLU and our supporters are uniquely situated to push for this kind of democracy reform, given our huge reach across the country. Our affiliates on the ground in every single state, as well as Washington, D.C. and Puerto Rico, our powerful state and local coalitions, and most importantly, our 9 million ACLU members and people power activists, all of you who are boots on the ground across the country. Together, we can turn the tide and elect representatives who actually represent their constituents and hold them accountable to protecting and restoring rights, liberties, and our democracy. We can do this and we must do this.
Deirdre, you got me fired up. You got me ready. You got me, what did you say, fired up and ready to go. Yes, thank you for reminding us that it all flows from democracy and having a representative government. Absolutely, we can do this. We must do this. I know you have a specific call to action. You are already getting there for everyone watching. So what can folks do next?
Yes. Well, as we continue to fight for our democracy and an end to racially discriminatory voting practices in courts and in the halls of Congress and in communities, we need all of you. You can join our Democracy Defenders Task Force to keep partnering with us in some of the biggest voting rights fights across the country. As part of the task force, you'd be kept in the loop on how you can take action as we fight together to protect equal access to the ballot, preserve the integrity of our electoral process, and defend the very foundations of our democracy. Be sure to join now at aclu.org/defend-democracy. So that's aclu.org/defend-democracy.
There it is. Thank you, Deirdre. Thank you. I'm ready. I'm ready to just run around the block, get to the streets, whatever we have to do. Definitely aclu.org/defend-democracy. Thank you so much. Before we shift to talk about some of these other cases, I do want to bring back Cecillia Wang for one moment to talk to us a little bit about the landscape for our redistricting cases. I think there's more that we can delve into there. So Cecillia, if I can have you for one more moment.
Sure, happy to fill you in. So what happens next after Milligan and Moore? Well, a lot of our cases were waiting for the Supreme Court to decide the Milligan case. The logjam is now broken. Since the 2020 census data were released, the ACLU and partner organizations brought 21 redistricting cases, challenges in court nationwide. Compare that to the US Justice Department, which only brought 3. Okay, that's the volume of work that we've been doing. 17 of those redistricting cases are now active, and we're off to the races with the pending cases. In Milligan itself, we are going to be fighting for a unity plan, a unity map in a special session of the Alabama legislature as a way of implementing the lower court decision, striking down the state legislature's 2021 map. And in the other cases that we have pending where we sued under Section 2 of the Voting Rights Act, we'll be going to trial. Of the 17 redistricting cases that the National ACLU brought, 11 have been on hold pending Milligan. We have a South Carolina racial gerrymandering case that's already at the Supreme Court and will likely be argued in the fall. And we have 7 other redistricting cases that will be going to trial between this August and next May, with the aim of getting fair and legal maps in place in advance of the 2024 elections. Our Ohio partisan gerrymandering case was trailing Moore versus Harper in the Supreme Court, and the Supreme Court granted cert in our Ohio partisan gerrymandering case, vacated the lower court decision, and remanded back to the Ohio Supreme Court. As Deirdre says, the real work will be not only in the courts in all of those cases, but also before Congress and with all of us in our living rooms as we're shifting the conversation in favor of equal access to voting and all of the other rights that we're fighting for.
Ooh, thank you. With the stats, Cecillia Wang, with the stats, brought 21 cases, 17 of them active. There is a lot of work ahead for us yet. Thank you so much for breaking all of this down for us. Both Cecillia and Deirdre, appreciate you all. Voting is the foundation of our democracy. And as you all have heard, the ACLU is fighting tirelessly for equal access to the ballot and to protect our electoral process. So I hope everyone watching is as fired up as I am about this work. With the elections that are approaching, we have to gear up as a community. I want to be very clear that there is no time for sidelines. We need everyone in this game. So we have to raise our voices. We have to vote our values. Now let's continue to move on to our next segment where we're going to discuss some of the other critical cases that were heard by the Supreme Court this turn. I'm going to bring back David to break down the rulings in the other cases that will impact our civil rights and civil liberties and affect the lives of individuals and families nationwide. So David, let's start with one of the last decisions of the term, 303 Creative. And just as a point of personal privilege, just as a person that holds my identities, this last term was really devastating on a number of levels. As a person who's a proud beneficiary of affirmative action, and then particularly devastating to me as a queer person in this country, this case with 303 Creative was very difficult. So the court sided with a web designer in Colorado who said she had a First Amendment right to refuse to provide services to same-sex marriages. And the ACLU filed a friend of the court brief in this case that implicates both the issues of free speech and equal protection under the law. And so tell us, what did we argue and what impact will the decision have?
Yeah, thanks, Amber. So we argued what we argued in Masterpiece Cake Shop 5 years earlier, where we represented a gay couple who had been denied service by a bakery because the baker objected to same-sex weddings. And this was essentially a replay of that case. In that case, the court ultimately ducked the issue, but said the fact that businesses have philosophical objections does not justify them in getting out of a neutral anti-discrimination law that governs sales. Justice Kennedy wrote those words. He's no longer with us. And this time, Justice Gorsuch wrote the opinion and said, actually, if a business is expressive, if it provides some kind of speech-related service in a customized way, and it objects to the message that treating everybody equally would send, its First Amendment rights win out over equality. We think that's fundamentally wrong. We think that when a state passes a law that prohibits discrimination across the board in businesses that serve the public, and when that law applies equally to hardware stores, which are not expressive, and architecture firms, which are expressive, it's not a First Amendment problem, and the architecture firm doesn't get to discriminate because its service is expressive. If that were true, then why wouldn't a corporate photography studio be able to put up a sign saying, we won't take headshots of women because we believe women's place is in the home? Why couldn't a baker who makes custom birthday cakes refuse to sell a birthday cake to a black family because he doesn't think that black lives should be celebrated? Why couldn't a college admission essay assistance service open to all refuse to serve minority applicants because he's opposed to minority presence in colleges and universities? They should be, as they long were, excluded exclusively for white folks. Those are all First Amendment protected ideas, but that's not First Amendment protected conduct. And what the court did here was basically create a First Amendment loophole to anti-discrimination laws. It's the first time it's ever done so. It's not the first time these arguments have been made. The court has previously rejected argument that a law firm could refuse a partnership to a woman because it objected to having women partners. It rejected an argument of a college and of a school that it could exclude black students because it objected to the message that educating black folks would send. And yet here, it simply turned its back on all of that precedent and opened up the door to discrimination.
So David, let's just look forward to the next term. And can you lift up some other key decisions from this term that we should know about? And then again, what we should be looking out for as the next term approaches?
Yeah, I think it's important to keep in mind, as I said at the outset, that we won more than we lost. And we've talked a lot about what we lost here, but we won more than we lost. And we won some big victories. The Indian Child Welfare Act, which is one of the few pieces of federal legislation that actually seeks to advance the interests of Native American tribes by keeping Native American families together, that was challenged on a host of constitutional grounds. Most people thought it was going to go down, and yet the Supreme Court upheld the Indian Child Welfare Act in an opinion written by Justice Amy Coney Barrett in a case called Talevsky, which involved the rights of victims of civil rights discrimination to sue their perpetrators, where the law is part of a arrangement between the federal government and a company, and the party who is discriminated against is not actually party to that contract. The argument was made, and most people thought it would prevail, that individuals can't sue, that those contracts are about relationships between the federal government and its contractors, and third parties can't sue. Supreme Court rejected that argument, again, 7-2. In a case called Tyler versus Hennepin County, the court held that the due process clause and the takings clause prohibits a state from seizing, in this case, a 92-year-old woman's house because she had back taxes, selling the house, and then keeping the entire proceeds, even though they exceeded the amount that she owed. And finally, in a pair of cases, very important cases about free speech and the internet, the court rejected an argument that Twitter and YouTube and Google and Facebook could be held accountable for terrorist violence because on their sites, ISIS and ISIS supporters had put up videos and other sorts of messages. And even though those messages, those sites prohibit such messages, they didn't identify them in time and didn't get them down. And so the argument was, you are liable. Had that been upheld, free speech on the internet would be dead, because internet providers would not be able to allow all of us to put up what we want without first vetting it through all of their lawyers. So those are just some of the really important victories that we had this term.
Thanks, David. And then looking ahead to some of the cases that we have in the pipeline that we know are coming.
Well, as Cecillia has already mentioned, the very important South Carolina racial gerrymandering case, we prevailed in the lower courts, and the Supreme Court has agreed to review that case. There is a very interesting case about whether the Second Amendment bars a law that prohibits domestic abusers from possessing guns. And the court will continue to take cases over the course of the term. So no doubt there will be many civil rights and civil liberties cases in the court next term. And one thing is certain: we'll be in there on each one of them, defending civil rights, defending civil liberties, and urging the court to do the right thing.
That's right, David. As I always say, ACLU, we don't have to get ready, we stay ready. Thanks so much for walking us through these important cases. I'll be coming back to you momentarily as we're turning to talk about the path forward and an exciting new initiative that the ACLU has launched, which you actually referenced earlier. So my friends, as you've heard during this town hall, the ACLU and our partners have had some great wins and successfully held the line on some very important civil liberties issues this Supreme Court term. There is absolutely no denying, though, that many of the court's recent decisions, like in the affirmative action case, our LGBTQ equality case, and of course the Dobbs decision, are setbacks for our constitutional rights and liberties. But be very clear, we are not deterred, and we have launched some new initiatives at the state level to protect and advance our rights. And so, David, bringing you back to talk to us about the ACLU's new state Supreme Court initiative. Tell us a little bit, what's the goal of this initiative? Why do we need it right now?
Yeah, thank you. I love this program, right? There are in the United States not one constitution, but 51 constitutions. Every state has its own constitution, and you can sue under that constitution in state court, and the state courts are permitted to read their constitutions differently from the federal constitution only in one direction. They can provide more protection. They cannot provide less protection. The federal constitution provides the floor, but states can go above that floor, and they often do. So we at the ACLU, because we have affiliates in every state, we've been, in the past, looking for opportunities where we can advance the ball on civil rights in state court in a context where the Supreme Court U.S. Supreme Court is not ready to go there, or maybe won't go there for a very long time. We've been doing that. Now we're doing that in a coordinated, organized fashion, looking for opportunities in many states where courts are actually fairly progressive, or at least open to our arguments, where the constitutions include protections that the U.S. Constitution doesn't include, for example, privacy protections, and going into those state Supreme Courts either as co-counsel to the party or as amicus to argue for the advancement of civil rights and civil liberties. And we've made huge progress already in states like Massachusetts, New Jersey, California. Those are some you would expect, but also Montana, New Mexico, Ohio, states you might not expect. And so, as Cecillia mentioned earlier, we struck down Ohio's map as a partisan gerrymander in the state Supreme Court. The New Jersey Supreme Court has protected criminal defendants' rights much more fulsomely than the U.S. Supreme Court does. The Massachusetts Supreme Court as well. Many state Supreme Courts have protected educational equity, the notion that students in public schools should have equal access to resources, whether they come from a poor neighborhood or a rich neighborhood. And we've been involved in a number of those cases. So I'm very excited about this. It sort of opens the door. These constitutions have been relied upon a lot less often than the federal constitution. People have sort of reflexively gone to federal court for a long time. And so we think there's tremendous opportunity in going to state courts using state constitutional arguments. And when we win in a state court using a state constitutional argument, the U.S. Supreme Court can't review that case generally because, the Montana Supreme Court has the final say on what Montana's constitution says, not the U.S. Supreme Court.
Yes, David, thank you. I'm so excited about this new initiative. It's a perfect example of some of the innovative ways that we are looking to not just hold the line, but advance and expand civil liberties and civil rights throughout the country. And thank you for that little lesson. I know we had folks that were like, 51 constitutions. I learned something today. Hopefully you learned a lot more than that, but that's one exciting thing to learn. So as we all know, the ACLU is a multi-issue organization with affiliates in every state of the country, as well as Washington, D.C., Puerto Rico. And the state Supreme Court initiative is really exciting because it leverages our unique ability to coordinate the work across issue areas and across states. Deirdre was talking about us having boots on the ground everywhere. And it's crucial as we work to protect and advance voting rights, abortion rights, LGBTQ equality, and so many of our other cherished civil liberties. The ACLU would not be able to launch new innovative strategies like the State Supreme Court Initiative without you all, our ACLU community, which is why we're so grateful to all of you who are watching now. We thank you so much. Your support provides us with the resources to stay strong in the fight. And along those lines, I also want to give a shout out, little whoop whoop, to the Guardians of Liberty who support the ACLU with their monthly gift. You all inspire us so much with your deep partnership in this work. Her steady and dependable support allows us to really be able to plan ahead and be innovative and to be able to act quickly whenever the need arises. And as we have heard, the need is arising often. And so we are very grateful. We're very appreciative. If you are watching and you are not yet a monthly donor, becoming one is one of the most powerful things you can do to support our work now and in the months ahead. So I'm going to invite you all to please go to aclu.org/monthly to make a monthly gift and to start doing a monthly gift today. So that's aclu.org/monthly. Really, please check that out. This is one of the most powerful ways you can support our work. That's my quick commercial. Freedom ain't free, my friends. So we appreciate everything that you do to support us in this fight. Now we are nearing the end of this town hall, and I want to move us into our final segment. I'm going to bring my colleagues back, all of them, one more time before they go back to the incredible work that they talked about today. I'd like to ask you all to join me. And I have one final question for the full panel. As we look beyond this Supreme Court term, and we're looking to charting the path ahead, what is your one call to action for each person watching? We have a lot of folks who are with us in the fight. We have a lot of energy that's on this call. The chat is blowing up on YouTube. And so tell our folks, what can they do? I'm going to start with David, then go to Cecillia, and then Deirdre will close us out. David, what's your one call to action?
Thanks. Well, first of all, thank you to all of those who have joined us today, because you've already taken a step to action by joining us for this call. And I would say, really, I would cheat and say two things. One is vote like your rights depend on it, and get your friends and family to vote like your rights depend on it. In democracy, that is our most powerful tool. That is the tool that the Constitution enshrines for all of us. That's how we'll get back abortion rights. That's how we'll get back equality in a meaningful sense in this country. So vote like your rights depend on it. And the second thing I would say is support those civil society organizations that are fighting for the rights you care about. Absolutely critical. You know, every country in the world has a constitution. Ours actually means something. And the reason it means something is because we have a robust civil society in this country made up of citizens coming together in organizations like the ACLU or LDF or Planned Parenthood, of people who care about a certain vision of the world and are willing to put their support behind organized, strategic fighting for that. So I think, you know, becoming a guardian of liberty, absolutely one of the most important things you can do to defend civil rights and civil liberties in this country.
Wonderful. Thank you, David. Cecillia, what's your call to action?
So I would call on you to join us in playing the long game. If you look at the arc of justice on the subject of voting, let's stick with that. In 1965, Congress enacted the Voting Rights Act, and President Johnson signed it into law. Why did that happen? It didn't magically appear in the halls of Congress up on Capitol Hill. It happened because Black freedom fighters in the South of the United States shed blood, sweat, and tears to make it happen. And the VRA is widely credited to the freedom fighters who specifically marched from Selma to Montgomery. And it's credited specifically to what happened on Bloody Sunday, March 7th, 1965, when John Lewis and other Black civil rights leaders were beaten bloody by Alabama police. The VRA came out of that. And it took almost 50 years for our opponents, those who wanted to hang on to the pre-civil rights era, to knock out a significant part of the VRA in Shelby County versus Holder in 2013. We're successfully fighting to preserve the VRA in courts, and we've won this term, as we already talked about. But the real work is going to be even longer term. It's going to be in Congress, as Deirdre described, and it's also going to be happening in your living room when you talk to your crazy uncle and try to persuade him that fighting for rights, fighting for liberties is the way to go. We don't get political change without first having those living room conversations. So I call on you to join us in the long game, to win back and preserve civil rights and liberties and shift the conversation in our country.
Thank you, Cecillia. And Deirdre, what is your call to action? You've given us so many already. I'm gonna ask for one more.
Thank you. Well, I would just echo what my colleague said. You know, we need you in this fight to protect rights and liberties. We need you to sign up and become part of the People Power program. We need your help in educating voters in every state in this country, in winning elections, in winning legislative battles, both in Congress and in states. There are fights in every state in this country around civil rights and civil liberties right now. And we need you in those fights. So please sign up, be a volunteer, get involved in your community. We need you.
Thank you so much, David, Cecillia, Deirdre. Vote and get your friends to do it as well. Support the organizations who are fighting for our rights. Join us in playing the long game. And thank you, Cecillia, for that reminder and the history lesson. I will just add to that we have been here for 102 years, ACLU, and we are all about the long game. We're not going anywhere. And what Deirdre continues to tell us is that we need you in the fight. Join us, sign up. And I will just add to all of that, just to pull on what Cecillia lifted up, please talk to your people in the dining room, the locker room, the board room, the classroom, wherever you have to talk to them, because we need everyone in this fight. My friends, we haven't come this far to only come this far. So I thank you so much, David, Cecillia, Deirdre, for having this conversation with me. And of course, our wonderful ACLU supporters, thank you for all you all do to protect our civil liberties and civil rights every single day. We are honored and proud to be in the fight with you. And thank you so much for everyone for joining us. We are able to do this work because of the help of our donors and activists. You all are essential partners in this fight. So again, please take the actions that we shared with you today and continue to raise your voices. We look forward to keeping you engaged in the work ahead. Thank you so much and take care.